morning and welcome to the 4th Texas Hispanic Farmer and Rancher Conference. My presentation today is on heirs property. I'll get right into it with the definition of heir property, which I'll admit is not a term that I was real familiar with until maybe a couple years ago, but I've known the concept for quite a while. Heir property, in a nutshell, and probably more widely known to us here, is basically property that does not have a clear divided title. It's technically property owned by two or more individuals. Usually those individuals are relatives, so they're probably siblings or maybe even cousins, depending on how many generations it goes on. Ownership of the property tends to pass via intestacy, and that just means that when that property owner passed away, they didn't have a will or a transfer on death deed. And therefore, any of the eligible relatives inherit and become new owners of that property without any real documented legal paper trail. And we don't know everybody's individual reason or anybody's individual reason for not making that will. But the study that UT did showed that 82% of Hispanic residents over the age of 55 did not have a will in place. And that's really high compared to the white counterparts of the same age. And be that maybe culture or just money might be an issue, there are a lot of reasons why a person might not establish a will and establish how any kind of property will be passed down to the next generation. Here's an illustration that I pulled from the farmers.gov website, which you've heard referenced a couple times in this conference. And it kind of shows, it's an illustration of how the number of co-owners of heir property can grow and become more complicated as time goes on. So here at the top we have maybe not the original, but a couple that has clear ownership of the property. They have the title, all the paperwork is in order, either they inherited it or they purchased it, but they have a clear title. If those two people pass away without a will, so intestacy, then it automatically goes to their children. And so in this case, they have 3 children, and the 3 siblings are now co-owners of that property. Well, if 1 or 2 of those, say Lady in Green and Lady in Red, pass away, and those 2 ladies had children of their own, now 5 people co-own that property. And so the grandchildren and then one of the siblings that didn't have children of his own. So now it has gone from an owner, a couple of owners that own jointly, to up to 5 co-owners. And there's no telling if these 5 co-owners all have the same thought about what they want to do with that property, how they want to manage it, if they even want to be involved with it at all. And so maybe coming to an agreement of how to handle that property and possibly what kind of production. Do they want to be farmers? Do they want to be ranchers? It's all gotten a little more complicated. It's very possible that you feel like co-owning property with your family, your siblings, and your cousins is a great idea, and it's a way for you to appreciate your history and your ancestry, and also look to the future and really build a strong family tie. But sometimes it's the family that's even more complicated than, say, business partners. So a few complications with heirs property come about, and it's because the ownership is unclear legally without documentation. One thing that comes out of that is that it's difficult to get federal benefits. And in our scope, we're talking about, say, USDA programs or any of the ag programs. It's not impossible, but it's a little more difficult. You have to take a few more steps in order to get those benefits. And in Texas, homestead exemptions are also affected by not having clear titles and divided property, in where you can't get a full homestead exemption if that's your situation. And then just moving forward with any plans that you want to make to use that land. Somebody might want to build a house, and another person wants to put in row crops or hoop houses, and you put in your hoop house where I want my people house to go. And when there's that kind of disagreement, it doesn't always stay nice and civil. Sometimes it could get ugly, and it all comes around because the property is not clearly titled and divided. So sticking with the great idea that you want to put your property into use for agricultural reasons, even if it is an heirs property, you don't despair. There are provisions, thankfully, in the 2018 Farm Bill that allowed for states such as Texas, who have adopted the Uniform Partition of Heirs Property Act. And because Texas did that, then what you can do is provide a court order that determines that the land is heirs property, or you can produce a sort of certification that the documented owner is deceased, so those original parents or grandparents, and that one of the relatives, one of the co-owners is working on retitling the land. So that they see, that way it shows that you're trying to make progress and actually make this situation right and get out of our heirs property and everybody have their clear titles. Some other options to put this land into use and into a USDA program, and there are lots to get involved with, is a tenancy in common agreement. And that means that a majority of the co-owners give one of the co-owners the right to manage and control and make decisions for that property. Another option is to show tax returns for the 5 years before whenever you go into the USDA office and show that that person has some interest in the property. Another option is self-certification, that the individual has control of the land and that they intend to use it for farming and ranching. And then you can even go to your specific county office. So if we're talking about USDA programs, that's going to start at the Farm Service Agency, so you can get a farm number. You go to the FSA office that is over wherever your property is located, and they can help you decide what kind of documentation will work for them. It's probably going to fall in these other areas, but there might be something that they can help you with that's specific to your county. Now those measures, the court order, the tax returns, the self-certification, those are meant to be temporary measures, just for now kind of things to do so that you can get into a USDA program, get that farm number, start in on a program that's a conservation program or a loan program, and really get to that hard but really great work of being a farmer. The idea of allowing those measures is that you will get to a point and you will work on retitling the property, the heirs property, into individual pieces that an individual will own or a family will own, but with very clear and defined legal boundaries and ownership. There's several ways to do that. Some of them cost money. The first one probably does. You find a lawyer that specializes or is very knowledgeable in real estate and how to deal with titles and deeds. Title companies obviously that's what they do, but try to find one that has a good reputation that you feel like you can trust, and they will definitely lead you through the process of surveys and documentation and filing at the courthouse and making things very proper. There is this great handout, a PDF, that it's available on the FSA website. I will put this link in the chat box so that you all can click it and take a look at it. It'll give you some information, some in more detail than I've given you here, and then it'll give you some ideas on how to start the process of retitling an heirs property. There's also this tool that USDA put out, this initiative that USDA is working on, the Heirs Property Relending Program. And the program itself was not for individual farmers, but it is for organizations who are going to help those individual farmers. And so those organizations that, as far as we know, haven't been announced yet, but they will be given funds and resources so they can develop staff and materials and networks to help producers get through that retitling process. And some of it might be money, some of it might just be technical assistance or maybe some kind of legal advice. And as soon as we find out who those organizations are, we will definitely network with them, collaborate with them to get that information to our producers that we deal with, or any producer that reaches out and says, hey, I really need some help in getting our heirs property cleared up. SADA's role in the realm of heirs property is to really collaborate with other organizations and with producers, and eventually with the organizations that are awarded part of the USDA relending program funds, to compile resources for producers. We want to be part of the network that helps producers get connected with whatever resources there is, whether it's funds or it's technical assistance, maybe it's some of those property and deed experts. And we can do that by offering information at the events that we put on, whether they be virtual or hopefully in person soon, and just making that connection and getting those resources to the producers. If this is something that you're interested in, if you find yourself or your family in this situation of being co-owners of heirs property, please reach out to me. My email address is here. It's aisha.cruz-reyes@utrgb. You can also like our Facebook pages. We have a couple. One is called UTRGB Texas Rural Cooperative Center, and the other being the UTRGB Beginning Farmers and Ranchers Program. In any case, you can find us at those places, and we'd be glad to help in any way. That concludes my presentation. Thank you again for being with us. I will take questions if there are any, but if something comes to you at a later time, please reach out. Thanks.
Yes, Aisha, thank you so much for the presentation. This is definitely a new topic for many of us, but of course, it's very important that we are aware of this information that you just presented. So thank you. And yeah, there is some questions for you. The first one is, can someone without a clear title still participate in USDA programs?
Yes. So thankfully, the farm bill, the last farm bill that was put out in 2018, that did kind of change the rules a little bit, so that they worked in some leniency for people who didn't have that clear title. And you do have to sign off on some documentations and show that you're working towards getting those titles situated and cleared up. But once you do that, then you take that documentation to the FSA office. You can then get your farm number and move forward with any of the programs, a conservation program, maybe a loan, or a disaster emergency program. That documentation gets you to the FSA number, the farm number, and that's your key to get into USDA programs.
Okay. How common are heirs property issues in Texas, if you know that?
Well, I'll refer again to that UT study that showed that not too many people, that there are a lot of people who are a little bit older that aren't making wills, and so that could ultimately lead to an heirs property situation. But even in conversations, I've had lots of conversations with NRCS staff or USDA staff, and when I've asked this question, it's always yes, that's so happening, and we see it a lot in our office. And a producer will want to go forward with the plan, and then he'll have to say, well, I have to talk to my primos about it and see if they're okay with it. I'm trying to avoid any problems of someone coming in and saying, hey, what are you doing here? I'm not allowing any kind of plowing or anything. So I know it happens. I am in Starr County, and I know it happens that there are a lot of undivided interests, and that makes it hard for even building a house on a piece of land. It just makes it very hard, and I'm sure it's all over.
Okay, there is a last question here. Does the Heirs property relending program provide money to producers?
Not to producers directly. If USDA opened this grant program the way I think they did, the way they have in the past, organizations across the nation put together a project or a plan for a project that's pretty specific in how they want to run it. They know just like we do at SARA, they know their constituency, they know their clients, they know their local needs, and they designed a program around that. So hopefully, I'm pretty sure that a Texas organization will be awarded, and then they will receive funds and provide technical assistance, and those organizations might be lending money to producers to clear up their titles. Again, thinking about how USDA works, usually that lending program for producers is going to be really low interest. It's going to be affordable and accessible. And that's what we really hope to see. We expect to see from that project.
Okay, I was thinking as you were speaking up, once a farmer or a person find an issue like this, do they work with a real estate lawyer, or who will be someone that could help them out? Like what type of agency?
A lawyer, an attorney is a good place to start, and not all attorneys will want to deal with this. But if they don't, maybe you know one, and they don't, that attorney doesn't feel so comfortable, they can refer you to one. You definitely want to find somebody who has experience and knows, maybe even knows your situation and how to deal with family issues and family documentation in the right way. And ultimately, the paperwork needs to end up at the courthouse, and that's when the whole situation is resolved. But it can be an attorney, it could be a title company too.
Okay, well, thank you. Oh, hold on, there is another last question just pop up here.
Okay.
So, are there any programs to help buy out other heirs who are not interested in farming and ranching? Okay, it's a long question, so if you want to answer that part first, and then I continue.
Okay, because really my answer was, I'm not really sure. I'm not really sure, but we can certainly look into how this heirs property relending program plays out with the organizations in Texas, connect you with those organizations, and then figure out what specifically they can help us with.
Okay, the other part of the question, is there data available to help level set expectation as to farming land prices?
There is, I imagine there is market prices, probably a real estate agent or a company, like the companies that make loans, they probably have good information on that, on what properties cost. I mean, sometimes you can go onto a real estate website and just look around and see what people are charging or asking for per acre in a certain, in Starr County versus Hidalgo County versus somewhere like Bexar County. They're all going to be very different depending on where they are. But looking at local markets, that's the beauty of the internet. Looking at local markets will give you an idea of those prices.
Yeah, nowadays it's amazing. You go to those real estate websites and pretty much they have a value for each property, just a projected value.
Yeah.
Okay, last part. In my experience, families' expectations about what a property is worth versus what is the economical farm value of a property are very different, which causes issues. That was just a comment.
Yeah, and I agree. I'm still in the mindset that an acre should cost $1,000, and they're going for $3,000, $4,000, $5,000.
Yeah, and even a lot more than that nowadays.
Yeah.
But yeah, thank you so much, Aisha.